Well, good morning and thank you very much for joining us. I am Yori Falani. I hope you had a great weekend. When talking about weekends, it was Friday, the beginning of the weekend, that the President signed the Electoral Act Amendment Bill into law. And since that time, for those who are interested in current affairs, in politics, and even, legalese, it's been one discussion or another. And indeed, we shall continue, because I dare say our viewers are going to have one or two things to add to it from all around the country where we're viewed from. Now, it's no more news that President Buhari has signed the Electoral Act Amendment Bill into law. But in doing so, he signed it into law and immediately was requesting that an amendment be made to it, and talking specifically about Section 8412, and quoting Section 8412. That's about my limit, because I have a lawyer besides me, and so when we want to start quoting chapter and verse of the Constitution, I'm in very, very, very good hands. Malachy Ugwumadu, lawyer and former president of CDHR. Thank you very much for coming on.
Thank you for the opportunity. Good morning, viewers.
Indeed, and people can see that we virtually snatched you away on the way to court.
Conscripted from the court.
Thank you very, very much. So, there we are. Now, first of all, I think we'll talk about it as we go along. Most everybody understands the implication of Section 8412, and it'll be explained as we go along, no doubt. But I wanted you to relate to the issue of some senior advocates of Nigeria, as was reported over the weekend, are not in agreement. They disagree with that request. So I wanted to ask you, what's your view on whether or not the act, the way it now stands, contradicts the Constitution?
Well, first of all, let me commend the Nigerian people, this time around led by the very vibrant, ebullient civil society that sustained the pressure, the momentum, leading to the signing into law this bill, which is now an act of the National Assembly 2022. Recall that the last one we had was in 2010, which is about 12 years ago. Now, my view is that it is a progressive act. It is deliberate. It has consciously taken care of a few aspects of the malfeasance noticed in our march to electoral freedom, albeit in the whole business of nation building. Now, if you take into account the fact that the entire essence of election is to guarantee participation of the electorate with a view to vesting legitimacy to the process, you will therefore understand why the amendments and the changes that have been effected are extremely of importance. Having said that, let me also congratulate the President, just to the extent that he eventually signed. Because if he didn't, we'll be back to the problems we had noticed from 2012, including judicial interpretations of the inadequacies contained in 2010 Electoral Act, as well as the gains we would have made with the signing of this. But just to that extent, because it was also of concern to me that we had to, all of those pressure, all of those energy needed to be dissipated before this bill was signed into law. We needn't travel that route. We needn't expend all of those efforts and those energies before we got this bill into an act. But finally, it is to say where we are now. The President signed in law. He said he appeared in protest. He entered a caveat to say, whereas I'm signing, in fairness to him, he requests that the National Assembly should discard Section 84, subsection 12, and allege that that is in conflict with the Constitution, guaranteeing, of course, the freedom of association and discrimination, Section 40, 42. Now, to the extent that it didn't ensure level playing ground between ordinary, when I say ordinary, I mean candidates without the advantage of appointees, to the extent that it immediately vests an advantage on people who has behind them, queued up, appointees of prospective candidates. To that extent, I imagine the president has seen it as one that already give instant advantage to. In other words, you are no longer guaranteeing a level playing ground for all participants, regardless of those who are political appointees or not. And this is with respect to conventions and congresses, where these political appointees are seen, are known, and accepted as automatic delegates to those conventions and congresses. So that is the argument of the president. But those who have taken a contrary view are also looking at the very other aspect of the Constitution, Section 171, subsection 4 and 6 thereabout, that is to the effect that the appointees of the president or the governor, as the case may be, ceases to be at the end of their tenure. So what has become debatable is, when do they resign? When would they pull out of that appointment? Is it before or after the congresses? I think that is where, now by and large,
and that's because of the time frame.
Yes, because of the time frame
that is recommended in the new
so by and large, what is an issue is the altruistic objective, is the pure motive behind that request on the part of the president. Haven't clearly shown what his reservations are. But what is not very clear is, to what extent can the president further make effort to review an already promulgated law? In other words, once you have signed, assented to a bill, it becomes an act. What you could do is to raise the concern you have raised now and leave it at that. It is the business of the National Assembly, the legislature, and in their wisdom as representatives of these people, to now say, we are reconsidering this section for 1, 2, 3 reasons. And that will be at their time. It may be important, given what they have come to realize after the signing, to say, well, that could be almost immediately, as the president of the Senate communicated after the exercise. But I think that most of the worries already shown, and I buy that to a large extent, is that you couldn't be signing this law or this bill into an act and mandating that a particular section in it must be removed. You can't go that far. The reason being that there is separation of power, and your responsibility is to assent. By the way, if you refuse to assent, the National Assembly has powers to override your refusal and go on, either by representing it or allowing the time frame to elapse, and it will become an act of the National Assembly. And we're getting close to that, given the preceding pressure, the preceding campaign and sensitization that attended this particular bill.
Well, as you say, it's an interesting scenario. I don't think we've seen it, I certainly can't remember, where it's like the president, well, I don't think it will be accurate to use the word reluctantly, because he had good things to say about aspects of the bill. But having said all those nice things, then said that Section 84, subsection 12 worries him. But as you've pointed out, he has signed it. First of all, I imagine it's commendable because he sort of overrode his own feeling that, look, if it were up to me and I can't do it, but if I were to do it, I wouldn't have put this one in here. You guys have put it in there. I'm going to sign it, but I request an urgent review. The National Assembly is also, at least in the report I read on Saturday, the Senate President reportedly was saying that they hope that the President's men will send, in good time, their feelings on the matter so that they can begin to work on it. So that's why your explanation has, come in useful, and I still have to understand how much clout the President really has to make a law according to what will satisfy him in the face of the National Assembly. But Mr. George has called in all the while in the meantime. Good morning, Mr. George.
Good morning, Uncle Yori.
Thank you for calling in.
Good morning to Malachy, my friend.
Good morning, Mr. George.
Uncle Yori, I think we should put the interest of the country before any individual. And the President has done well by finally signing the bill into law after so many back and forth in attempts to please particular sections of the country or particular individuals. In my view, Uncle Yori, it shouldn't be like that. It should be about what is of greater benefit to the generality of Nigerians. I've never seen a country where a bill is passed and the president that is to sign the bill, because of a particular set of people like his appointees, he says, make an amendment so that my appointees can be favored. You cannot eat your cake and have it, Uncle Yori. If any appointee wants to contest for a position, there are rules. Obey the rules. Why do you want to hold on to your office and at the same time contesting any or whatever the post is, either in the party or in the general election? Go and stay on the same line with other contestants and do the contest. Uncle, you and I know how people use their appearances of office in this country to influence what they want. If a minister, for example, is coming to the polling booth as a serving minister, and if you were to come in the opposite direction as someone who is no longer in the office, do you think he can influence, which of the positions can he influence all the agents at work there? It is the one where he is serving. If these people want to come and contest for whatever position, let them give way and then go and contest.
Okay.
That's where the freedom lies.
All right.
But not that you should subject our laws to the whims and caprices of certain individuals.
Okay.
I don't feel comfortable with that as an individual.
Okay. Thank you very much for calling in, Mr. George. Malachy, a lot of people might also feel that way. The law is the law, and it's interesting. The president has signed it, so he's considered that much. So look, it's my duty. Not all duties are pleasant. Maybe Mr. President didn't find this aspect of his duties particularly, pleasant, but he did do the right thing. He went ahead and signed it. And then coming back to the point that Mr. George is making, this whole matter, there are other people who have also said that, look, if we go by the new provisions as contained in Section 84 of the law, that of the amended electoral law, if we go by Section 84:12, it is felt that too many people who have ambitions will have to leave office in order to comply, and therefore I've read somewhere that it's not an easy job to replace a cabinet, especially if more than a few of them relinquish their positions at the same time. But please, when you want to comment on this, let me quickly take, I also have on the line from Chidi in Kafanchan. Good morning, Chidi in Kafanchan.
Good morning, Uncle Yori.
Good morning, sir. Thank you for calling.
Good morning to you, Barrister Ugwumadu.
Thank you, Mr. Chidi.
Yes, I have to commend the President for assenting to the bill as it has been amended. That means he has done the statutory thing that the President is expected of doing, and which Nigerians, I must say, are very much happy about. But the onus still lies at the capacity of the INEC as presently constituted in conducting a free, fair, and credible election. So the Nigerians are always showing apathy when it comes to elections. But I want the INEC to work in conformity with our laws and our constitution to ensuring that things are done in such a way that Nigerians will develop interest in voting, and when they vote, let their votes count. I encourage Nigerians to partake in our democracy.
Okay.
Thank you, and God bless Nigeria.
Thank you very much, Chidi. So, to the point.
Yes, I believe this angle that Mr. Chidi has raised is a very germane one, and I think we need to also focus on. So my preliminary statement was that this is a very progressive bill, and to the point that Mr. Chidi has raised, it has a way of rekindling the interest of the Nigerian people in making our electoral processes participatory. And how do I mean by that? If you look at the new act as it stands, there are I think the words of the president, very revolutionary provisions there. The first being that the funding, for instance, with which the election monitoring body is expected to prosecute the elections, are expected to be disbursed a whole year before the election, 365 days. And this has become a law now. So there is no question of appropriation and refusal to release funds or release a very insignificant, infinitesimal aspect of the funds that are appropriated. That way, the election monitoring body is able to deal with all manners of procurement, all manners of exigencies, including, of course, early preparations, for instance, procurement of sensitive materials, which most often than not are done outside this country, given the volatile nature of our operations. That is the one. The other is that the law even empowers INEC as a referee and an arbiter to some extent, not to go beyond the verdict of ROs, that's returning officers, in terms of results that are declared, and giving INEC the powers to review what the ROs have done. So we are gradually dealing with instances in which people won election, either by hook or by crook, some under duress. We have such cases even with the last election. And what they usually will tell you is go to court.
Yeah.
Now, putting you, who is supposed to be on the offensive, on the defensive. This time around, INEC has the powers to review what its RO has done. That way, you are beginning to see that some of the strategies that the politicians have to undermine the system and frustrate the will of the people are gradually being curtailed by that. What is more, you can see an act that now makes a copious provision allowing INEC to factor in the challenges of persons with disabilities and making it in a way that allows them to participate as much as every other person.
All right. Thank you. And also, let me just welcome Mr. Kabir Akingbolu. Mr. Akingbolu is a lawyer and public affairs analyst. He joins us via Zoom. Good morning to you, sir. Well, I did think he would be joining us via Zoom. Are there? Yeah, Kabir, can you hear us?
I can hear you very well.
Ah, okay. There you go. All right. So if you've been following, first of all, thank you for making the time for us. Would you like to address the question of that some observations that have been made that, look, one of the downsides of complying with Section 8412 in the amended bill is that we might have a whole chunk of cabinet members, people in the presidency who have ambitions, a whole chunk of them will now have to resign. And it is felt that this is not the way we've been doing things before. So give me your thought on that, given that lawyers are not all on the same page anyhow about this whole matter. Some lawyers see it one way, others another way. Would you like to address that question of complying might mean that if there are quite a number of ministers and all sorts of political appointees that are ambitious, then they have to resign?
Yeah, you see, I think I agree with it completely, because if they don't make it like that and they should resign, there will be conflict of interest. And I can tell you, with the way the law is structured now, there is going to be a serious diversion of
Kabir, the network is what it is. I think the local balance is that the network get as it be for the moment. But maybe Malachy will pick up on that, and as soon as it stabilizes, we'll come back to you, because it's a question I had first of all posed to Malachy.
The flip side to your conjecture, your projection, is that in our climes, given the low-level performance of state actors, you could also have a situation, a preponderance of situation, in which so many people will not be courageous enough, will not be willing to contest elections. That can be a possibility. I'm talking of ministers after ministers, first of all, that were never removed, many of whom have performed abysmally low. We're just talking about our nationals in Ukraine and how their fate has become worsened because the ministry responsible for the welfare of these people have not been as proactive, at least as other countries, in terms of rescuing people. Such people cannot. What are you resigning to do? You better stay put and finish up with where you are and go home and rest. So I'm also thinking in trying to push the argument that that is proper, particularly from the standpoint of giving a level playing ground to all constituents. I'm also thinking about instances in which preponderance of the political appointees will not be resigning for the purpose of contesting elections.
Okay, one moment, please. Mazi Okorafor, good morning, sir.
Good morning, sir. Good morning. Malachy, SAN in making. Good morning, sir.
Good morning, sir.
Malachy making the sound SAN. You see, President signing the act is not a deal. It is the responsibility of the president to sign anything that comes out from National Assembly. So all these ceremonials, situation Nigeria with them, well, because it took long time, maybe 1 year, 2 years before the signing. But the question is this: if a minister resigns or anybody in the cabinet wants to go for an office, what is the Constitution talking? You resign. Let's say, for example, let's say Ministry A minister resigns, fine. The permanent secretary is there. If you check where 80% or 70% of the job done in the ministry, the perm sec that does it, and other directors under. So the minister resigning, as far as I'm concerned, is not creating any vacuum. But the question is this: all these things we are glamoring. Fever, we have problems. At the end of the day, Barrister Malachy, sir, how do we solve this problem? Every election we get, we cannot get the result before 7 p.m. every day. It must enter midnight and go back to the next day. Why it's common local government election, even this by-election, you see them entering midnight. To me, this is where we're supposed to find a system or put of our system presently to make sure any election we conduct within 24 hours the results are out. It will bring and reduce tension. A reduce tension whereby you conduct election, it will take hours, and we have to look into this issue. We saw what happened in the by-election, where some boy was still carrying an election bus. At the end of the day, the results still came out from that bus they carried the election bus, and they still declared the results that the person who carried the election bus and disappeared won the election. What type of country are we finding ourselves? That is the issue. The Electoral Act, we have it now. Look at, are we now, they say they will go to court. By the time you go to the court, before you start, maybe by this week or next week, all those people that won the election, they will be sworn in. Is that what we are working? What is the issue of the Electoral Act? What we want is prompt in anything we are doing. That is the essence of the Electoral Act. Whatever we are doing, we should follow the sequence.
All right.
Minister resign. Pastor, come and do his job. Thank you very much, Mr. President.
Indeed. Thank you very much.
SAN Malachy.
Thank you.
Okay, Mr. Kabir Akingbolu on Zoom. I wonder if it's any better now. Can you hear us? There were glitches on the line. Is it any different?
Yes. Can you hear me now?
Okay. What I'll do now? Yes, indeed, we can, louder and clear. But let me quickly go on a break. We'll be right back, and when we come back, I'll come straight to you. Stay with us, please. The rest. Okay, welcome back, and we're looking at the Electoral Act Amendment Bill signed into law by the President last Friday. Section 84, subsection 12 has been causing some sort of tizzy. We have barristers Malachy Ugwumadu, former President CDHR, and Kabir Akingbolu, public affairs analyst and legal practitioner. We also have on the line, and let me quickly go to Kola in Okota. Good morning, Kola.
Good morning, Uncle Yori.
Good morning, sir. Please go ahead.
Thank you for this discussion. And I also want to say hello to your guests.
Okay.
Now, my view is that we should first of all thank the President for signing the bill into an act. The Section 84, 12 that is being in contention now, I really don't see why we should continue to stress it, because it is not only about the presidency, it's about all, including the state assembly, the governors. The law is not only for the federal government. I think we should be able to educate people to see it in a larger perspective. I recall vividly that in the past, the restriction of contesting elections was more or less during the military era, that say that civil servants that want to contest election in the past must resign their appointment 3 months before maybe before the election, not about even the primary that we're having now. So I think we should just leave this as it is. We should thank God that at least the bill is a revolutionary bill that has been mentioned by your guests. I think we should take it from this angle and then let it go. I recall that the President has put more or less a caveat, which for me, as has been said, there's a need for this clear delineation of legislative and executive activities. So I think that we should leave it at this. And then before I go, please, I just want to also make this opportunity, because your guest also mentioned the issue in Ukraine. I have a son that is also coming from there, but one of the issues they are facing is the fact that there is a current provision that before you can come to Nigeria, you must have a travel certificate. And that travel certificate can only be obtained if you have your COVID test. You have to go online. And that's creating, even airlines are not allowing Nigerians to come in from Ukraine. My son has had to spend 2 additional nights in Vienna because of the fact that he doesn't have travel certificate. I just felt we should use this opportunity to talk to the authorities to suspend that provision for people coming from Ukraine. Thank you.
Thank you very much, Kola. So sad, and we hope that your son and indeed other sons of Nigerians over there, and daughters for that matter, exactly. So many, exactly, up to 5,000. So thank you very much, Kola, for chipping that in, and I think the authorities have heard that. You have to make it a lot less bureaucratic. Okay, coming to you now, Kabir Akingbolu. We were talking, before the line went bad about the practical, difficulties. Well, depending on how you see it, because there are those who see it differently. But this has been talked about. I don't know what you think about that aspect of the job, because people are saying it's the law. Now the president signed it. I noticed that the National Assembly, I understand not to be belligerent with the executive, unnecessary belligerent with the executive, but it seemed to me that the National Assembly was leaning over backwards by what the Senate President is reported to have said, that we're now expecting, we hope that we will get from the presidency, directions on the way their mind is working, so we can see, I'm paraphrasing now, of course, so we can see what we can do to, I don't want to say rectify the situation, but address the situation. That surprised me. Did it surprise you? It's law. That's what the National Assembly's business is. It has done it to the best of its ability, but now it is saying that it is waiting on Mr. President to send it info on how to go.
Yeah, you see, there is a clear indication. It's an impressive aspect of democracy, in that the National Assembly is to make the law, the executive is to execute. So what the National Assembly is trying to say is that we are not to execute the law, we are to make the law. Law is what it is, but the way they tinker with it, if the executive wants to tinker with it anyhow, that is another ball game. That is what the National Assembly is trying to do, to say. But I agree. It's a very positive law. It's a law that will impact on our judicial process positively, but some aspect of it calls for serious concern. I have been doubting why, and I don't still have answer to it, that why is it when our election is around the corner, that we start to amend our law? The National Assembly has been there for 3 years now. Why is it that it is this time around that this law is being made? Now again, when it's made, they want it to take immediate effect. We have staggered election across the country. We have in Osun State, we have in Ekiti State. If they are making it to apply immediately, there are going to be some errors, I can tell you. And again, on the issue of primaries, the way they have now said that presidential primary, House of Rep and all that name must be submitted in June. This is going to cause a lot of problem, the way I see it personally, because some of the political parties were caught unaware. Now, for them to start doing primaries, congresses, some of them have not even done their convention. So it's going to cause a lot of issues. But from for all intents and purposes, it is a good law, and I expect the Nigerian government to make good use of it. And with the way INEC timetable has come out, it is almost very clear that the executive is not tinkering with the law, is not also trying to control the INEC anyhow. So if you look at it from that angle, you will commend both the executive and the legislature at the same time.
Okay then, we have a call from Uche. Uche in Awka, Anambra State. Good morning.
Good morning, Mr. Yori.
Good morning, sir.
And good morning, Barrister Malachy SAN in the nation.
Good morning, Uche.
Okay, we also have Barrister Akingbolu on Zoom.
Okay, Barrister Akingbolu, I also greet you, sir. Mr. Yori, what I want to ask now is this 84-2 or what have you was it not there?
Section 84, subsection 12.
The president rejected it ab initio. Was it not there? Was that clause not there when you rejected it in, I think around December or thereabout? After 1 month, after full 1 month, and he did not complain about it. And I don't think that place was there, because he only cited the direct and indirect and the this consensus. That was what he cited. He went to Channel Television and he said once they amend it, he will sign. Now only for him to wake up and now he was now complaining about this. I think I want to believe that if not of the clamor and the outcry, he would have rejected it again. Citing this one now.
Okay.
Probably, if you come up with another one, he will cite another thing, and to be going until when we get to 6 months before the election, he will now cite another ECOWAS, what have you.
Okay.
So I don't understand, and I don't understand. How can you not? He should have cited it then. Because He was with that vision for a full 1 month, going through each morning, afternoon, night. And he said he was going to, he wrote to INEC then. He wrote to the Attorney General then, seeking for advice from everywhere. I don't understand. If I were at the National Assembly, I would just ignore whatever he said there, because I don't think. All
right.
But to be
I hear you. Thank you very much. Let me come over, because we've not heard as much from you. Let me come back to you, Kabir. What would be your thoughts that? And I've read some of that kind of commentary over the weekend, that the National Assembly is under no obligation to act on the president's comments. It's just a comment. They're not bound by it, but they have this nice relationship. I don't know, they would, of course, not want to be seen to be in the pocket of the presidency or the executive, but they still have cordial relations. What would be your thought on what was just suggested, that the National Assembly can go on its merry way and just ignore all of that? Those were just comments from the president. They're just comments like anybody else's.
Hello? Can you hear me?
Yes, Kabir, we can. Go ahead.
Yes. Now, the comment of the president is just aside. It's just like what we say in law that we call obiter dictum, when the judge has delivered his judgment and is making a comment. He has no choice here. He has signed it to law, and it has become the law. Whatever his reservation can only be made before he signed it into law. Having signed it into law, what we have now is the law as passed by the National Assembly. The opinion of the government or the executive, whether president or whoever, does not count again. We have the law. It's no longer a bill. It's now an act of the National Assembly. It is the law to guide our elections. There is no more sentiment, no more emotion, no more opinion.
All right.
So the law is what it is, and it must be applied in that way.
Okay, cut and dried. Mr. Ibe in Port Harcourt, good morning, sir.
Sir, good morning.
Please go ahead.
I want to contribute to the discussion, please.
Go ahead.
Hello?
Yes, we can hear you. Go ahead and contribute.
Yes. Yeah, good morning, Mr. Yori. I'm really very happy that the electoral law was signed into act. I'm happy that the electoral law has been signed into act. So, electoral law has been signed into act, and the president making some observation on the section 84 or something like that is immaterial. So, those appointees that want to contest for election should resign before 3 months to go and contest. It has been like that all the time, so we cannot continue going back and front. This country does not belong to some individuals. It belongs to all of us. Thank you very much.
Indeed. Thank you as well. Thank you very much. Now, the import, if you were just to cut right through it, if you are a political office holder of any kind, then you cannot, either vote or be voted for in your primaries. You were speaking earlier about creating a level playing field, because it seems to me that all those people have now become known. Nobody knew them from Adam. You know what I mean. Of course, we know prominent women, but there are people that would not have been known had they not been made public officers, political office holders. Now, using that clout and all that, all that to now go into office, is that what you were referring to as it gives those people an unfair advantage against, for instance, a friend of theirs or a colleague of theirs back in their constituency, wherever it is,
without such an opportunity?
Without such an opportunity.
Precisely, that's the point I was making. And that is also the concern of the president, for which reason he believes that the right thing to do is to ensure that that section doesn't quite exist, just so that that level playing ground that we all talk about will be guaranteed. But you have seen the argument forth and back we must also moderate it in a way that enables us to focus on what the law is now. Whether in or out, the law as presently constituted is at section 84, subsection 12. Is part of the Electoral Act.
It is, but the issue now is that there are those who feel that that particular section was put in there to, really hamper, shall we say, anybody in the position that we're talking about who wants to be a senator, wants to be president, wants to be governor. Sorry, you can't come forward, or if you must come forward, resign what must be seen as a lucrative and very public, positioning that you have, and then just go to the queue like everybody else.
So, but even before now, even before this Electoral Act was passed into law as an act of the National Assembly, we have always had that position. Public office holders who occupy offices are expected.
Yeah, but the time frame now.
That is the issue now.
The whole issue. Let me bring in Kesandu. Kesandu in Owerri, thank you for holding on. Good morning.
Uncle, you're a good you.
Thank you for calling. Good morning.
Very good you too, sir.
Good morning.
Okay. You see, I personally think and feel that particular area that is in contention, what is the essence of the primaries? Allow the person, there is a law for before it's honorable before the main election. That one is fine. I don't even understand why this issue of resigning before primary should even come in. That is one too. Some of us are becoming so skeptical about the implementation of this. Let me give you an instance of what happened in a way on Saturday that we had a by-election. It was reported that that some INEC staff with the electoral materials were carted away. INEC staff. And after this result was declared, what is the rationale behind this? So, what exactly? Now we are having a new Electoral Act. Where is this place now enshrined in that Electoral Act? Where are we going to get this safety? Are we still going back to the old normal that you can do anything and go away with it? So, Minister, how do we even face this thing now? That INEC, who should have even withheld the announcement of this result, where their staff was scattered away, and it was seen that people were whisked away with electoral materials, and after a result was announced, how do we bring these things into perspective? It's becoming a huge problem for us, and it will help. It will make some of us lose confidence in this whole thing. Thank you very much.
Indeed, thank you very much. Now, if lawmakers do not amend this constitution, then it means that ministers and other high-ups like that simply cannot participate in the whole 2023 journey, starting, of course, with the primary. Is that really, to your mind, is that a minus, given that we're trying to reform, our whole electoral process? The president said it was revolutionary. But now, all that, this whole matter about if you could only adjust this section, which would favor my men, some of the people that I have, they will feel punished. What do you think about that whole era? Do you think the president is, okay within his rights?
Well, I think we've dealt with that. I have expressed my position on that. The position of the president is that retaining it will run in conflict with the Constitution. And I've cited the constitutional provisions that he's referring to. That is the constitutional provision that allows for freedom of association, as well as provision that stands against discrimination. In other words, you cannot single out this category of persons and say that these rules will apply to them when it doesn't apply to other people. But
if we were to go that route, you'd have to approach the courts, right?
The first thing he has done is to appeal to the National Assembly to say, come, you still reserve the right.
And if the appeal is ignored?
Of course, those who feel affected. I mean, we've done a lot of cases based on that. If your right to freedom against discrimination is breached, you can contest it. And in this particular instance, you give particular reasons why you feel that that aspect of it has been, and seek the order of the court. And the court has sufficient powers to strike down certain provisions of an act. Don't forget, it's not the Constitution, it's an act. By Section 1, Subsection 3 of the same Constitution we operate today, if you find any of the provisions of these subsidiary acts in conflict with the express provisions of the Constitution, that section can be struck down.
Okay. Sarauta, if I got that right, in VIA.
Yes. Good morning, Uncle Yori.
Good morning.
Very well. I commend you and your guests.
Very kind of you, sir.
Can you hear me very well?
Yes, we can hear you loud and clear.
Very well, Uncle Yori. I commend you and your guests with respect to the issue tabled. And Uncle Yori, I look at it very much sentimental. If the president, after signing this law, will come out, having become an act of the National Assembly, will come out and make requests or recommendations for amendment. It's ideal, it's good. But having become an act, his requests, his recommendations are only persuasive to the National Assembly, cannot be binding on the National Assembly. I think the National Assembly should look at what is right for the national populace, for Nigeria, for us to move on and have a credible election. That's my humble contribution, Uncle Odi. You guys are doing well.
Thank you very much.
This program. Thank you so much.
Thank you very much. Mr. Akingbolu, it is reported that on the day of the signing, the president, I think, met with the Senate president and Femi Gbajabamila, his counterpart in the House of Representatives, and that is on the one hand. Now, I've also heard some rumors that, you know, there are members of the National Assembly, let me not go to any house now, members of the National Assembly who are quite frankly not interested in further amending the bill that has just been signed, because even the headlines on Saturday were saying that the president wants an amendment immediately after signing it. So there are those that are not. Is there a way? Can you understand that, Mr. Akingbolu? Can you understand the attitude of some people, if indeed there's anything to the rumors that they're not interested in tinkering further with the bill? Can you understand their reasoning? Oh, that's a frozen picture. Can you hear me?
Yeah. Myself, I can hear you.
Okay. I said, can you understand the leaning of some in the National Assembly reported to not be interested in further working on that bill? Never mind what the president has said, even though the president has met with them and has specifically reportedly asked them to expunge that section. Can you understand those lawmen who are saying, no, we're not interested?
No, it will send a wrong
Okay, the network has interfered again, but I think he was going to say it would send a wrong signal. That seemed to be what happened, what you were saying when the network just went haywire. So just picking up on that point, if indeed, Malachy, if indeed this supposition of mine were true, those legislators that are not interested reportedly in tinkering with the bill further, as the president has requested, can you understand their point of view?
It reinforces the point we have made earlier, that there is in the operation of government in Nigeria the principle of separation of power.
Yeah.
It is that Mr. President has found it expedient to sign the law, not as a gratification, but in the discharge of his constitutional responsibility
and duty
and performance of the functions of his office, which is why I like people to moderate. We've thanked him, but we should limit it there. It is just like when the governors provide rules and amenities. We must exit this over-glamorization of what they do with our money and our direction, as it were. You're just carrying out what you are under a duty to do. So, having said that, it is to say that we're still conscious as a nation and still alive to these separated arms of government, who, by the way, are supposed to work together and get governance functional. And in this respect, the bill, which has suffered a lot of forth and back, as we articulated in the civil society, this would have been the 6th time he's refusing to sign this bill if he hasn't assented to it. I mean, what manner of country has all of those luxury of time, dissipate such energy, and then come to the point where you eventually, after 5 times or 6 times, eventually find that you are still quarreling with one. Okay. Well, I think it is just to reinforce that argument that you have done your bit. Thank you, Mr. President, but allow the country to move forward with the kind of improvement and innovations and progressiveness that this act, bears at the moment.
Malachy Ugwumadu, lawyer, former president, CDHR. Thank you very much. And also our thanks to Kabir Akingbolu, lawyer and public affairs analyst, who joined us via Zoom. I can't say that the network has allowed us much joy this morning, but we thank God for the bit that we were able to get out of you, Kabir Akingbolu. Thank you very much, and I'm sure next time maybe it'll be in studio, and then we'll be able to enjoy you a lot more. We also thank all the viewers who called in, and many that couldn't get in as well, that wanted to contribute to this same topic. We probably might return to it, depends on what the public clamor for that is. So that's our program today. Please join us tomorrow for a fresh edition. I am Yori Folarin. Bye-bye for now.